Now let us look at the second source of international law. So we were discussing sources. The first source was custom, and the second source of international law are the treaties. This is as per Article 38 of the International Court of Justice Statute. Now, treaties are considered on a much better footing when compared to customs. Why is that? Because they are more modern and they are a deliberate method of forming law. When we are looking at customs, the customs are where customs as a source of law were non-deliberate. Okay, they were continuous usage by the countries and they were generally accepted. But treaties as a source of international law are deliberate in nature. Why they are called deliberate? Because the countries have by themselves agreed that they will follow this and this particular international law. So this is a deliberate attempt in forming the laws. Okay, deliberate attempt in creating law. So that's why treaties are called as deliberate in nature. Now, if we refer to Article 38, it says that international conventions, whether they are general or particular. Okay, so we have to look at general word here and particular. So, what are general conventions and what are particular conventions? Let us look at that. So, general conventions. And particular. So general conventions are relating to those conventions which are among the countries, okay, which are among the entire world. For instance, if we take an example, for instance, the UN Charter, okay, the UN Charter or the ILO Convention. So these are general conventions, okay. When we talk about particular conventions, we refer to the treaties between 2 or 3 countries, okay, between India, Pakistan or Bangladesh, or between two countries or a group of countries. Then we are referring to a particular convention. Example of it can be the bilateral treaties, okay. Bilateral treaties are the treaties between two countries, okay. So this is the example of particular convention. Let us go back to our definition. So international conventions are general or particular and they establish rules expressly recognized by the contracting states, okay. So what they do, they create these conventions, they create a set of rules, a set of rules. Now these rules are agreed by the states, okay. So states have prior agreement with respect to these rules. So this is the definition of treaty as per Article 38 of the ICJ. Now there are different terms which are used for treaties or for these conventions. These can be said as international agreements, pacts, general acts, charters, or through statutes, declaration or covenant. So all these are different terms used for conventions, okay. Now the creation of written agreements, if we describe treaties further, it is a creation of written agreements whereby states participating bind themselves legally to act in a particular way, okay, or to set up a particular relation between them. So what is a treaty? See, what is a treaty? Treaty is nothing but it is a written agreement, okay. So these are the essentials of a treaty. First, it is a written agreement, okay. Second thing is that these are voluntary acts by states. Okay, so states have voluntarily entered into these treaties. These are voluntarily in nature. The states have entered why? To bind themselves. Okay, these are the essential conditions to bind themselves by these law. Okay, or to set up relations between them. Relations between states. So these are the core explanation or core definition of a treaty, that a treaty is a written agreement which is voluntarily entered by a state through which it binds itself or it creates relation between two different states. Okay, so this is the key idea of a treaty. Then comes the obligatory nature of a treaty. Okay, so why are treaties considered obligatory? Treaties are considered obligatory because of the principle of customary international law principle. What is the customary international law principle? Pacta sunt servanda. Okay, this is a customary principle. It was based on international customs. Okay, pacta sunt servanda. What does this means? This means that treaties or pacts, treaties should be respected. Okay, this is a very important maxim which you must remember if you are dealing with international law. Treaties should be respected. Pacta sunt servanda. Okay, so this is a customary law principle, and on the basis of this principle, international treaties are obligated or international treaties are followed. So treaties can also be divided into two different aspects. Okay, so we can divide these treaties into two different aspects. First is the lawmaking treaties. Okay, and second is the treaty contracts. So these are the two kinds of treaties. Now, what are lawmaking treaties? Lawmaking treaties are intended to have a universal relevance. Okay,